Hello there. Welcome. Employment Law Show. We're back for another week, another 30 minutes to educate you indeed about workplace rights, employment laws. That's what we do, and dispelling some of the myths and misconceptions therein. There you go. John Scholes here, and as always, Lior Samfiru, ready to do all the heavy lifting. I'll give you his contact information and the rest of the team at the firm. First, 1-855-821-5900. help@employmentlawyer.ca. That's always the email we refer to. And the website, which helps you guide your way through your employment career and all the rights within, is pocketemploymentlawyer.ca. Rolled into that nicely is the severance calculator. What does it do? It's a severance calculator. It calculates your severance. But this one's really accurate, and it's been used, literally, not hyperbole here. Millions of people across the country have tried it out. It takes about 30 seconds. It's anonymous. It's a great tool. Again, free for you to use at pocketemploymentlawyer.ca. Okay, Lior, on the week this week, we always have a main topic, as you know, discipline at work. 5 key facts. We'll get to some calls from one of our radio shows across the country and other questions as well. So let's roll up our sleeves, as you say, get rolling with the week that was. What do you got going on this week, pal?
John, employment law is what I have going on. You know, that's the life that I lead. I talk about employment law. I talk about employment law here. I talk about employment law on radio. I talk about employment law at work. That's kind of what I do. That's why they call me the employment lawyer. But the good news is there's a lot to talk about. There's a lot of things that I can tell you, a lot of rights that you have that you must understand. That's why we've been able to do this show and our radio shows for many years, because there's information that we can provide. There's questions that I get asked all the time that I want to share with the audience, because you may not have an issue right now. I hope you don't. But maybe something happens next week and all of a sudden you want to understand your rights. Well, by watching this show, you'll be prepared. You'll have the answers. You'll know when something is wrong is happening. You'll know when to reach out and how to get help. That help, of course, is very easy to get. Beyond the show, I'm not going anywhere. You can reach me and my team at the office. We'll give you that contact information again throughout the show, so no problem there. Happy to talk to you and happy to help you deal with your wrongful dismissal, your constructive dismissal, your human rights violation, your employer not treating you properly, harassment, bullying, you name it. You have rights, and we'll get to those, of course, on every show. But always like to start off with a case of the day, a case that I dealt with very recently. Well, I spoke with a gentleman who, unfortunately, was unceremoniously fired by his employer. Why was he fired? Well, he was fired because the company that he worked for, his boss, found out that he was looking for another job. So even on his vacation days, he was out there looking for another job, interviewing. Another company told his employer that, just so you know, we got a resume from this employee of yours. So he found out he was kind of, busted, if you will. He was looking for another job. His employer got very upset, said, you don't want to work here, no problem. Out you go. We're firing you for cause. Get out of here. We don't want to talk to you again. Well, this guy, of course, was upset. He was looking for another job, but he certainly wasn't prepared at that point to leave the company. So thankfully, he did the right thing. The right thing is to call me. So he did, and we had a good discussion. So here's what I told him. It's not cause. The fact that you're looking for another job is not even a form of misconduct. You've done nothing wrong. You're not doing it while you're supposed to be working. You're not spending your time that you're getting paid looking for another job. You're doing it on your own time, either evenings or your vacation days, and that's okay. Now, if your employer is not happy about it, they're absolutely allowed to let you go. But that's a without cause termination, and they have to pay you severance. This guy had been there for over 3 years. Severance for him can be as much as 6 months' pay. So very important reminder there, because these things happen. You're not always going to be happy in your job. You may be looking for work. The fact that you're looking for work somewhere else is not reason to discipline you. It's not a basis for you to be let go for cause. That's not how it works. You've done nothing wrong. Now, I don't want you, of course, to be looking for work during work hours. If you're being paid by your employer, you're supposed to dedicate the time that you have to that employer. But beyond that, you've done nothing wrong. You're going to be owed severance if the company lets you go. And of course, just like this gentleman, call me.
If your employer feels jaded by you looking for, that's not cause, right, to be let go.
And listen, I may be upset too if it was my employee. I get it. But if I decide to let that employee go, I know that I have to pay severance, full severance. I don't even get a discount. If I'm willing to do that, I can certainly do it. But to use that as a basis for cause to avoid having to pay severance, that's illegal.
Would the employer or the employee have to argue there is or there was not dereliction of duty while they were doing that? I mean, hey, I kept up on my duties, my sales numbers are great, I was just doing this on the outside. That's no big deal. Well, or the employer have to say, no, you're slacking here, this is why.
Well, if the employer is the one firing for cause, the employer has to prove that the employee wasn't doing their job, that they were slacking off, they were doing other things instead of doing the work that they're being paid for. The employee doesn't have to prove it. The employer does. And if the employer doesn't have that proof, they cannot fire for cause and they have to pay severance.
In the situation, Lior, where someone's been given working notice by an employer, in 6 months we're going to let you go, do they have to allow you time within that 6 months to seek other employment? Because you already know you're out the door, right?
They don't have to legally, in the sense that there's no law that says you must allow that employee. But here's something you want to keep in mind. If your employer gives you notice of termination, let's say it's 6 months or whatever it is, and they won't allow you or give you the opportunity to look for work, what does that mean? It means that because it's now going to be more difficult to find another job because you have less opportunities to do so, they may owe you more notice or more severance. So the employer may be hurting itself by not supporting you when you're looking for another job. So a smart employer is going to say to the employee, hey, if you need time off, let us know. We'll work with you. If you need to do something in your efforts to find another job, that's fine. We'll even give you a reference letter. We'll give you a good reference, because by doing that, that actually helps the employer. They may then have to pay less severance. So again, if you're an employer, be smart about it.
Let's get to a bunch of phone calls. Again, employmentlawyer.ca to find a radio station near you in your neighborhood or close by. You can tune in every week and ask your questions live on air. Phone call number 1 for today's show, Lior, is coming up right now. Listen up.
If my company decides to move to a different city, which is approximately 94 kilometers away from their current location, and I've been employed for about 23 years, and I was just wondering what my rights are.
How much extra time is it going to take you to get to this new location?
2 hours for a round trip.
What kind of a job and how old are you?
I am 53, and I'm team lead for the production line.
I think the legal term is
that's
94 kilometers. Come on.
That's the technical term.
Wow.
And on a recent show, we were talking about this exact scenario where you're being relocated and it's going to impact you in a significant way. Now, 94 kilometers and 2 hours instead of, whatever it was before, that's a big deal. So what does that mean? Of course, you can't stop your employer. You can't say, oh, I've decided you're not relocating. It doesn't work that way. But what you can do is consider your employment as being terminated. The terms of your employment have changed. Your employer decided to relocate, to change the terms of employment. Instead of you commuting half hour, you're commuting 2 hours. It's a big deal. So you can say, no, that's a constructive dismissal. I am owed my severance. Anytime the relocation is probably more than an hour, that's a constructive dismissal. But of course, you want to call me before you do anything. The last phase in this analysis is to figure out how much severance he's owed. We know it's a constructive dismissal. We know he's owed severance. How much severance? We're going to go for that to the tool that John mentioned earlier, pocketemploymentlawyer.ca. Use the severance calculator there. Let's see what that gives us. So we know that this person has been there for over 20 years, and he's in his 50s, and the company says, you don't get severance because we're not letting you go. Well, guess what? Because it's a constructive dismissal, you see right there, he's owed anywhere from 20 to 24 months severance, up to 2 years of severance without actually being let go. So that's why I use the severance calculator. Of course, it's free and anonymous. Go to pocketemploymentlawyer.ca.
All right, there's phone call number 1. Lior, phone call number 2. Let's hear that as well.
So my husband was having difficulty because he had to work a lot of night shifts. So his work asked him to provide a doctor's note. His doctor provided that, saw a sleep specialist as well. And a sleep specialist confirmed that he has work shift intolerance and can't work nights. And now his HR team has just sent him a letter saying that we've reviewed the document, that they don't find evidence of the disability.
Yeah, night shift's tough, man. Did it for 8 years.
It is tough, and if you have a certain medical condition, it can make it, forget about tough, it can make it impossible to work. So here's where this is kind of strange to me. This employer knew enough that it should ask the employee for a doctor's note. Absolutely. But then when it got the doctor's note saying, yeah, we're not buying it, No, it doesn't work that way. Your employer doesn't get to say if they agree or disagree with the doctor's note, okay? If your doctor says, in this case, you cannot work night shifts for medical reasons, guess what? That's it. It's over. At that point, your employer now has to find a way to accommodate you. They don't get to say, oh, we don't believe it. We think your doctor is exaggerating. We think you're making it up. No. If your doctor says that, that employer has to accommodate. Now, they can ask questions to your doctor. They can say, other than working days, is there other accommodation we can provide? Maybe we can change his duties a bit. Maybe we can change the hours or change the length of shifts. Is that going to work? But if the doctor says, no, the only thing that he can do is work days for medical reasons, that employer has to accommodate. Even if it's difficult, even if it's going to upset other employees, they have to do it. Again, the idea of a doctor's note is your doctor's telling your employer something. Your employer is not going to be able to question that, debate it, disagree with it. If your employer is not doing what your doctor's telling them, call me.
And there we go. Third phone call is on the other side of the break, and our main topic as well, 5 key facts about discipline at work. So stick around. We're going to answer all those questions coming up. Stay with us. Phone number 1-855-821-5900, and to reach out by email at least, help@employmentlawyer.ca. Stay with us. We're coming right back. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. As promised, 3 phone calls per show. Radio show, employmentlawyer.ca. Find a station near you, whether it's here in the GTA in Toronto or across the country. And take the next step, actually. When you're listening, phone into the show, ask your questions. You might appear, well, your voice anyway, on this show at a later date. So phone call number 3, Lior, is coming up right now. Let's listen up.
My husband is a truck driver by trade. He was working for the company for almost 6 months. The equipment was faulty. The tractors were faulty. And he reported this to the company because it was unsafe practices and it goes against everything he knows. And he gave the company and spoke to them about it, expressed his concerns, and then got a termination letter. Is this lawful?
Seen this before, right? Yeah.
I really hope that our viewers are shaking their heads right now like you and I are, because it's not legal. We were talking about this briefly in a previous show. You have the right, but I'm going to say the obligation, to refuse unsafe work. You should never work if you know or believe something is unsafe. You could be a danger to yourself and others. And God forbid, if something happens, man, oh man, are you going to regret that you continued working? So you can and should and must refuse unsafe work. And when you do, your employer cannot punish you. Your employer cannot discipline you or ignore you. What can your employer do, or what must your employer do? Take it seriously, investigate and fix the problem. Now, if your employer disagrees that the work is unsafe or that the equipment is unsafe, what happens then? Well, then they must bring in an inspector from the Ministry of Labor who is going to inspect the equipment and determine is it safe and is it not. And if it's not, your employer is going to have to fix it. If it's safe, at least you know it's safe, and you still cannot be disciplined. So this person was fired, truck driver, because he had the audacity to complain about unsafe work, illegal. By the way, it happens often with truck drivers. The equipment, the machine, not safe. You don't have to continue working. You can and should refuse it, and you cannot be punished in any way for doing so.
You just imagine an employer that want to cut corners by, sweeping it under the rug. Imagine the ramifications if A, they were hurt, or worse on the job. That'd be the end of your business.
That would be the end of your business. It could be much worse than just that. Someone could get hurt, God forbid. So, no, that's why we have laws that and require the company to take it seriously and protect employees that bring these issues to the attention of the employer. That's exactly why, because the consequences of not doing that can be disastrous.
All right, main topic time, discipline at work, 5 key facts. You got to know these. Number 1, document all forms of discipline and criticism. Document everything, right?
That's right. So if you're being disciplined, if you're not, if you don't feel that your employer is telling you kind of things the way that's correct, the way it is, you have to document discipline. Now, if you're an employer, by the way, you also want to document. So documenting here works for everyone. If you're an employer, you want to document that there was discipline. You want to tell the employee, and if you tell them something that they did wrong, follow it up in writing. If you're an employee, document everything. By doing that, people can later not deny that something happened. They cannot say that it's all false. So whether you're an employee or an employer, when it comes to discipline, always document something. And of course, if you're an employee and that employer is telling you something, it's not in writing, you put it in writing for them.
Just an email is fine, even if it doesn't get replied, doesn't matter.
Absolutely. Yeah. Email is perfect. I prefer an email than just writing something down for yourself. Write an email confirming what was said, what was done, and why. By doing that, you're creating that record, and that's all you need.
Number 2, this one is for the employers, actually, and this is a step they often quite miss. Employers should implement progressive discipline before that termination.
So you don't go from nothing to a termination when it comes to discipline. There are steps in between. So maybe there's a warning, maybe there's a second warning, maybe in some situations can even be a suspension. The idea is this, that if your employee is doing something wrong, you have to use progressive discipline. The discipline gets worse up until at some point, hey, there's nothing left. We can let someone go for cause. We can terminate employment. But you don't get to terminate if you didn't do the work, if you didn't build the case. So the best way for an employer to discipline is to start with minor discipline and escalate from there. And if you do that, you may be able to justify a termination for cause. If you skip steps, you're probably going to find yourself on the wrong side of a wrongful dismissal.
What we're talking about this week is 5 key facts about discipline at work. Number 3, Lior, and a lot of people don't realize the significant disciplinary actions. We're talking demotions, even pay cuts may lead to constructive dismissal.
So an employer has a right to warn you, give you a final warning. An employer has a right to suspend you with pay as a form of discipline. In most cases, an employer does not have a right to suspend you without pay. In most cases, an employer doesn't have a right to demote you. Of course, we're talking about non-union employees here, different in a unionized setting. So in a non-union setting, those things, a suspension without pay and a demotion, probably a constructive dismissal, even if you've done something wrong. Now, in some extreme situations, if you've done something really bad, there may be opportunity to do a disciplinary demotion, but that is rare and difficult to do. In most cases, if your employer demotes you, this says that's for disciplinary reason. You did a bad job, so we're going to demote you. Constructive dismissal. If your employer suspends you without pay as a way to punish you, again, in most cases, constructive dismissal. Be mindful of that, and if that happens, call me.
That suspension without pay, is that because, you're on suspension, but it's kind of like being found guilty before your day in court? Like, you know what I mean?
It's such an extreme measure
right.
that our courts have said that you just don't get to do that. It's that bad. And certainly you can't be suspended without pay while your employer is investigating what actually happened, because as you said, well, let's punish you to figure out if you should be punished. But even if you do deserve quote-unquote punishment, in most cases, a suspension without pay is not something the company is allowed to do.
All right, discipline at work fact number 4, performance issues alone, just by themselves, rarely justify termination for cause.
So this goes back to the principle we were talking about on a recent show, is that the termination is the capital punishment of the employment relationship. It's reserved for the worst offenders. So you having bad performance, even if it's legitimate, it's almost never on its own going to be a basis for a termination for cause. It could be a basis for a termination without cause, meaning you have to get your full severance, but not for a termination for cause. Now, the only time, well, not the only time, but in most times, if your company wants to rely on performance issues to terminate for cause, they would almost have to show that you're doing it on purpose, that you're deliberately doing a bad job. That's difficult to do. So in most cases, even if your performance is not up to snuff, you can't be fired for cause. And if you're fired, if you're let go, you have to get your full severance.
All right, 5th and final fact kind of wraps it up nicely with a bow for the previous 4, Lior. That is, seek legal advice if you're disciplined unfairly or lose your job, always. always.
Listen, clearly, and the reason why we say that is because in most cases, that discipline, that termination for cause is not legal. It's not done properly. Again, in 22 years, my gosh, of doing this, I've seen this more times than I can ever hope to count. Company thinks they're doing things correctly. Yeah, look, this person did something wrong. We documented it, so we let him go for cause. No, because it's such a high bar to terminate for cause, most cases they don't have cause. And remember, there's no such thing as 95% cause. Either they have cause at 100% or they don't have it at all. So yes, call, give me a shout. Let's talk about your disciplinary situation. Let's talk about your termination for cause. Chances are you have rights.
All right, short break. Back into more of your questions, emails, and employment right rapid fire to wrap up the show again this week. In the meantime, reach out to Lior, 1-855-821-5900. Help at employmentlawyer.ca. Stick with us. We're coming right back. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca. And welcome back. Thanks for hanging out through that short little break here in the Employment Law Show. You always have the opportunity before, during, and after the show to reach out to Lior and his team. Make that phone call, back it up with an email. The phone number, 1-855-821-5900. Help at employmentlawyer.ca, and we've used it and made reference to it several times on this show. We do every week, and we tell you to use it anytime. Pocket employmentlawyer.ca. Lior created the website, included in that with all the information we talk about on the show. You'll have access to the severance calculator as well. Plus, live streaming. He actually does have time to practice law once in a while. Live streaming on Facebook, YouTube, and LinkedIn. You want to join Lior and the rest of his lawyers at the firm at stlawyers.ca. Okay, here's the question, Lior. My 40-year-old sister started working in a contract technical role for a few months before being offered permanent status. She held the permanent position just shy of 3 months before being fired without cause. She was told she was on probation and not owed anything. Is this true?
It's not true. It's not true at all. So let's break this down a bit. Probation. Let's talk a bit about that. So you're only on probation, number one, if you sign an employment agreement that says that. So it's not automatic. Probation is never automatic. You have to have an employment agreement that says that. And as a practical matter, you really can only be on probation for 3 months, the first 3 months. Why? Because the only time the company can let you go without paying anything is in the first 3 months, and of course only if your employment agreement specifically says that they can do that. So as a practical matter, yeah, anytime you're past 3 months, even if the company says you're on probation, even if you sign something that says you're on probation for 4, 5, 6 months, it doesn't matter. If the company lets you go, the law is going to look at you as a regular employee, and you're going to get severance as a regular employee. So this person's been there beyond 3 months, was let go. They're owed severance regardless of what the company says. Doesn't matter. So the last question is how much severance? We're going to go back to the severance calculator. You'll find that at pocketemploymentlawyer.ca. We're going to use that right now, and let's see what that gives us. So we know this person is 39 years old in a technical role, been there for only 6 months. Company says, yeah, I know you're on probation, you don't get any severance. You see right there that this person is easily owed 2 months severance. And John, that's probably conservative. This person can be owed as much as 4 months severance, probably. So that's why I use the severance calculator. Probation, short service, long service, you got to check it out.
So if I'm saying, I'm going to outsmart you, Lior, I'm going to make my probation 6 months. How about that? Doesn't do anything, right?
Doesn't mean anything. Right? Keep on, because if it was that simple, a company can just say, yeah, you're on probation for the next 3 years, and if we let you go, we don't pay you anything, or 30 years. It doesn't work that way. Yeah. The only time you can be on probation, practically speaking, is the first 3 months of employment, and only if you sign an employment agreement that says that.
You know, you're displaying right there with the pocket employment lawyer. That's 6 months. Most people, their mouth would be agape, going, 6? That much severance? That can't be right. A couple months severance for 6 months? No.
And remember what I told you, that's actually conservative. He's probably owed more than that. So short service employees with, say 3 years or less, are treated disproportionately better when it comes to severance than long service employees. So yes, it's absolutely common that someone that's only worked for a few months is going to be owed a few months severance. Just because you work somewhere for a short period of time doesn't mean you're going to find a job immediately, and that's why the severance is there.
All right, got another website for you to use freely and anonymously. All kinds of different ways to reach out beyond the show. Terminationquestions.com. Terminationquestions.com. Give it a spin. Lior, the question from it: I was placed on a temporary layoff due to a slowdown. It's been over a month now. What happens if you are on a temporary layoff past the allowable time? Is an employer allowed to extend it?
Well, this question assumes within it that there is an allowable time. It assumes that there's a period of time during which you can be put on a temporary layoff. Well, guess what? That's not correct. For most employees, okay, a temporary layoff is not allowed. Meaning, if you're put on a temporary layoff, you may not have to accept it. You may be able to treat it as a termination of your employment and get your full severance. You don't have to wait a month, 2, 6, etc. You may be able to do that right away. An employer doesn't have a right to do that in most cases. There are some cases, if you sign an employment agreement, for example, that gives them that right, that may be different. But for most employees, that's the answer. So when I get questions, well, how long can they keep me on a temporary layoff? The answer is they can't keep you at all. You may be able to consider your employment as terminated. So it's up to you, the employee, not up to the employer. It's up to you to decide when you've had enough, whether it's on day one or another time. And at that point, you can get your full severance. As I always say, before you demand your severance, before you tell your employer, I'm not okay with this, call me so that we can do this right.
Is it different if they put you through the ringer one time previous being on a layoff and you come back?
It might be, yeah, absolutely. So the problem is, I've just said that an employer doesn't have a right to put you on a temporary layoff. But let's say you said, okay, I'll accept it. I'll sit at home for 3 months. They call you back. You went back. Well, by doing that, you're now potentially given the company the right to do it again. You've created that precedent. So the one thing that they didn't have a right to do, because you allowed it to happen, they may be able to keep doing it and doing it and doing it. So you want to keep that in mind. You don't want to open the door if bad things are going to happen when you do that.
All right, let's roll on quickly to wrap up the show with employment rights rapid fire. Here we go. Okay, Lior, number one for rapid fire this week. Can my employer change my duties significantly without my agreement?
No, they cannot. For most people, that would be a constructive dismissal anytime you're faced with a significant change. So you may have the right to say, I'm not okay with it, constructive dismissal.
Rapid fire number two. Can my employer base my severance package on salary only and not my commissions or bonus?
Absolutely not. Severance must include all components of compensation: salary, bonus, commissions, benefits, car allowance, pension. All of that must be accounted for.
Number three, can my employer determine when I retire from my job?
No. There's no mandatory retirement. You can work as long as you want to. You're the only one that can decide that, and you're also allowed to change your mind. So if your employer tries to do that for you, that could easily be a human rights violation.
And can my employer force me out of my job by making things difficult for me?
No, that again is illegal, potentially a human rights violation, potentially a constructive dismissal, as long as you're able to prove it.
One final one. Can my employer monitor my work emails or internet use without my permission?
Yes, they can. If you're using company computers, company emails, they can monitor you. So if you don't want your company to see what you're doing, or you don't want them to know what you're doing, don't do something that you otherwise would regret.
There's your rapid fire. We are done. The contact information to close out the show one more time: 1-855-821-5900, help@employmentlawyer.ca, and the website pocketemploymentlawyer.ca. We'll see you next time. Thank you so much.